Okay, I guess we'll get started. This is Dan Garrison from Fresh Start Funding.
This is Matt Hartley, also with Fresh Start Funding.
Today's webinar is on growing your practice and helping more people in 2020, and we're going to talk about how you can accomplish both of those things by offering clients post-petition payment terms through the use of bifurcated Chapter 7 engagements. But before we get started, we'll tell you a little bit about us and how we got started in this business and what it is that we do, and then we'll kind of jump into the meat of it.
So Dan Garrison, my partner and friend, he's an attorney, as am I. And Dan's been a pricing attorney for up to 25 years. 25 years now. And so Dan's practice was primarily focused on commercial bankruptcy. It was national practice, and Dan's won lots of awards for different turnarounds he's accomplished. He's a national speaker and a national author on bankruptcy topics, including a couple articles in the ABI journal about things we're going to be discussing today.
Is that about it?
I can go on for a while, but I'll stop there.
We're always a little self-conscious when we do this. Matt Hartley, my partner in crime here, is also an attorney who's been practicing 27, 28 years now, something like that.
A couple years.
I'm actually older than he is, which he likes to rub in my face, but he's been practicing longer than I have.
Yes, he's 6 months older.
Yeah, so Matt's been practicing for quite a long time. He started out his career in big law in real estate and corporate finance, and pretty quickly recognized his entrepreneurial streak, and he got into private lending during the boom cycle and was involved in that at a pretty high level for a number of years. And then after he wound that portfolio down in the Great Recession, started doing a bit of consulting work in the restructuring space, took over a couple of large companies that had failed and wound them down. And then looking around for the next thing to do with his life, he settled on consumer bankruptcy and actually started a firm here in Arizona that he grew really quickly to be the largest filer in the state of Arizona. He was filing as many or more than 100 cases a month at times. And really his story about what happened to his practice and how he discovered bifurcation ends up being kind of the origin story for Fresh Start Funding too. So we'll talk a little bit about that, but that gives you a little bit of an idea of who we are. We've been at this with Fresh Start Funding for a couple of years now, and Matt, maybe this is a good time to talk about how your individual practice kind of led us down this path.
So, in my practice, as Dan mentioned, I was a high volume filer. We lots of cases, sometimes, quite a bit more than 100 cases in a month. We're very busy, especially following the downturn. There was lots of cases to be filed, plenty of clients for everybody. But as the filing started to decrease every year, as I'm sure you've all experienced, there was just less and less people that could file. Ended up being price wars starting, as particularly the bigger filers were really fighting on price, kept dropping their rates, and I was caught up in that as well. And then one day I was actually looking at the filings, and I saw a local attorney here actually filed more cases than I did in a month, and I was very surprised by that. And of course a little angry, I guess. But so I wanted to look. I thought maybe he dropped his prices, and I went online on Pacer, pulled up some of his Form 2030 fee disclosures, and saw that actually he was charging quite a bit more than me. He was really charging the rates that we used to charge back when we were all really busy. And then even more interesting in his disclosure was he wasn't collecting all the money up front. He was collecting, in some cases, nothing, in some cases a little bit, but the bulk of the fee was unpaid at the time he filed the fee disclosures. So I did more digging into this, and that's when I found bifurcation. And realized, zero down was starting to happen, more and more around the country. So I did a lot of work, learned about that, and we'll get into more details about that. But I did obviously adopt it in my practice, and it was awesome. It was not only did it help my firm financially, but I helped a lot more people. Stop losing people throughout the entire process because they didn't have money. I was now able to give them the option that, okay, if you can't pay up front, then we can put you on a payment plan, get you filed right away, get the creditors to go away. And it was just, it was great. Like I said, it was benefited me and the clients.
Yeah, and that's really the fundamental premise of what we do here at Fresh Start Funding. We've kind of adopted the mantra of doing well by doing good. And that's kind of what we're going to talk about today, is the opportunity that you have to help more people by offering post-petition payment terms. And in the process, grow your practice and do much better yourself. Before we get into the nuts and bolts, I didn't talk about some of the housekeeping. So we are going to take questions at the end of our presentation today. Those of you who are familiar with Zoom will know the toolbar down at the bottom of the screen there. You can go ahead and type in your questions in the Q&A section at any time during our presentation, but we will hold off until the end of the presentation to answer those. We'll also provide you with some information at the end of the presentation about how you can get in touch with us and how you can access some of the forms and information that we've developed over time that'll really help you kind of dig in and know quite a bit more about this than you'll even get, in our 45-minute webinar today. So really where we'd like to start with this webinar is why. I mean, why should someone consider adopting bifurcation in the practice, Matt? Maybe you can kind of drop into that and talk about the benefits.
I mean, the obvious benefit is when someone goes and speaks with a bankruptcy attorney about their financial problems, that they generally don't have money. And they need the relief. There's legal remedies, obviously stop garnishments, foreclosures, et cetera. And attorneys can help, but the big problem they have is they don't have money. We actually find across the country, talking to attorneys, that for most attorneys, about half the people that come in their office don't retain them. And that 50% are not retaining them. Either they're saying, well, they can't afford the attorney, or they're saying, well, I got to think about it, whatever. But it turns out that they just don't have the ability to pay, and they don't want to admit it. And so they leave.
Yeah, the system really is kind of upside down from our perspective, because in Chapter 11, Chapter 13, there are mechanisms built into the bankruptcy code to let people make post-petition payments, and the attorney's fees are considered administrative expenses of the bankruptcy estate. But Chapter 7 has been kind of left out in the cold, and if there was ever a group of people that are most desperately in need of terms to be able to pay for bankruptcy, it's your typical consumer Chapter 7 debtor. And so, that dynamic really is what drives a lot of the why behind bifurcation. And the first thing, just as a blanket matter that we see across the country, is that attorneys are able to increase the number of filings that they're doing, increase the number of clients that retain them by offering this. And that's because of a number of different related dynamics that go along with this.
Yeah, because the first one I was talking about was with half the people not even retaining you by doing nothing different in your practice, but having this as an option for your clients, you're going to pick up most of that other 50% that are walking out of your door. So you can almost double your practice just by having this as an option available for clients. But it goes further than that, because the attorneys that really get the benefits of zero down, they incorporate it into their marketing. And so your marketing is more effective. So if you're doing social media marketing, Google ads, you'll find that more people will respond to your ad when they see it's zero down, and it's clear to them that they can get relief right away without having to come up with $1,500, $2,500, whatever it is that you're charging people to file the case. So right there, you get the benefit of more effective marketing. As I mentioned, more people will file, sign up when they come to your office. But one of the interesting things is you get more referrals. I was surprised by this at first in my practice. I always got lots of referrals, and any attorney's been doing it for a while gets referrals. But my referrals really went up when I started offering zero down. And what it was there's so many people that were surprised that they could get a zero down bankruptcy. I mean, a lot of people knew other people with financial problems, and as soon as they were able to get filed, they would tell people about it. And it was always interesting, if we do one case in a company, all of a sudden we get lots of people from the same company, because they tell their friend they filed, and their friend like, well, how can you afford $2,000 or whatever it is to file bankruptcy? And they mentioned, well, no, there's this firm that will file the case right away, stop all the creditors, and have easy payments I'm going to make for 12 months, after. And so yeah, the referrals were pretty crazy.
Yeah. So, every stage of the funnel, basically, the response to your ads, the percentage of people who actually show up for consultations, the percentage of people that will actually engage you once you sit down with them in a consultation, and then the number of referrals that you get off of that established client base all change dramatically when you start offering zero down. And so, we see a wide variety of results across the country, but invariably, if someone actually incorporates zero down and offering post-petition payment terms into their marketing, we see practices double, triple, even quintuple, 6x. I mean, sure. We see some really amazing results for attorneys. And the beauty of it, again, is that the attorneys are doing much better, but they're also doing better because they are helping more people who couldn't otherwise afford to hire an attorney to help them through bankruptcy. And maybe it bears touching on that just a little bit. You know, the reason that this dynamic works is that there is just such a large percentage of people out there that are literally too broke to go bankrupt. They can't afford an attorney. And so what it drives them into is either a layaway plan kind of a solution, which all of us have done at one point or another in our careers. Yeah. But that forces them to come up with the money again over time while they're still fighting off creditors and things. Or they file pro se and they end up being a burden on the system. And national statistics show that they get discharges at about a 30% or more lower rate than represented parties do. Or they just forego bankruptcy altogether and just keep languishing in debt. And some national studies over just the last few years have said that people are actually languishing longer outside of bankruptcy than ever before, and at a much higher personal, family, and societal cost than they ever have before. So this really is sort of a win-win. Yeah, for sure. And one of the things too, you know, attorneys and especially in larger metropolitan areas have really had to drop their fees a lot to stay competitive. Yeah. And not that this program's about, you know, charging clients more, it does get you out of the price wars. And it does allow you to get your fees back up where they were in the past and where they should be now for the work you're providing to clients. So one of the interesting things we have clients do when they sign up with us is do a calculation for the work that they do. And we have a fee calculator to help attorneys. But when attorneys who are charging, you know, especially if you're charging anywhere near like $1,000, when you break it out into all the work provided by you and your staff and what your true effective hourly rate is, I mean, it's $100 an hour if you're lucky. Yeah, or less. Yeah, we see it. It's not rare for us to run across attorneys that are effectively getting $75 an hour for doing Chapter 7 work. And the really ironic thing is that a lot of them are doing other work, either hourly, non-flat fee bankruptcy work, or they're doing other consumer law work with divorce or criminal defense and the like. And they're really regularly charging and getting $250, $300 an hour for that work. Yeah. And yet they're getting $75 to $100 an hour for Chapter 7. And so one of the things we talk about is reasonability of fees. And as we'll talk about, you know, how you do this correctly, one of the concerns is that your fees need to be reasonable. And so there's this balance to be struck between, you know, feeling that liberation of getting out of the price war, where someone will go down the street, you know, to your competitor who's charging $100 less, regardless of the fact that you are a more experienced, higher touch, better attorney than that person down the street, but also making sure that, you know, you don't charge so much that a judge or a trustee is going to see your fees as unreasonable. But the fee calculator that Matt talked about really can help you get a grasp on what is a reasonable fee using the lodestar analysis, which is the standard that applies in bankruptcy. Yeah, which under Section 329, as I'm sure you guys will know. Let's talk about it like a real example. I mean, just really kind of drive home, you know, the challenge that attorneys are facing. I heard this the other day from one of our attorneys talking about how actually it happened to be a woman came in, she had children, she wasn't married. She had just gotten notice of a garnishment that was about to start. She literally was crying in the office, telling the attorney, you know, I have to stop this garnishment. If they garnish my wages, I'm not going to be able to buy food and pay my rent, keep my car going to go to work. I mean, it was just going to be a complete disaster. In a lot of states, you know, even minimum wage workers who are supporting kids can have up to 25% of their wages garnished, which is just crippling to them. Yeah, it really is. And so after going through everything, you know, the attorney realized, you know, bankruptcy was the right choice for her. Chapter 7, she qualified for it. Clearly would stop the garnishment, get these creditors out of the way. She didn't have any money. But since he had just recently signed up with us, he had the other option of saying, I understand you don't have the money to pay me, but I do have another option. It's you know, I can't remember now if he used the word bifurcation, but he basically explained to her that he has an option where he can get her case filed right away. He did it for nothing down and allow her to make payments over 12 months. And those payments, I believe looking back, that they were about $200 a month. So it's like about a $2,400 fee. But that $200 was a fraction of what the garnishment was going to be for this woman. And she was, you know, sure she could afford the $200. It gave her the option and relief. She was so happy, so appreciative of the attorney being able to do this. And we've all been in those consultations with someone in like a situation too. And you as the attorney are stuck, if you don't have the zero down option, you're stuck with, well, if I turn this poor person away and knowing that, you know, it's going to be disaster for her and her family, or do I do it, you know, pro bono and hopes maybe they'll pay me later or something? I mean, it's really tough for the attorney, and you don't want to say no to these people, and sometimes you have to.
and they're upset. But again, back to the story with this guy. So as soon as he gave this option to this person, she wasn't expecting this. I mean, she was so happy and so relieved. She of course signed up with the attorney right away. He got her filed, stopped the garnishment before she lost any money, and put her on a payment plan, and it worked out great.
Yeah. So lots of benefits here, both to your client, the system, candidly, that isn't going to be burdened with pro se filers, and to you in terms of growing your practice. So I guess then the question becomes, well, how does this all work? How do you actually offer post-petition payment terms? And Matt, I think your first reaction when you found out about bifurcation was similar to a lot of attorneys, which is, how can you collect post-petition payments without violating the automatic stay, without potentially violating the discharge injunction at the end of the Chapter 7? And as a practical matter, how do I make sure that those fees are legally and ethically collectible?
Yeah, and I guess my initial thought too is, are you just relying on these, the goodwill of these debtors to make payments? Because that doesn't really work out very well either. No,
we have some clients in some rural areas where almost every client is someone that you know or is related to you in some fashion that have been able to do that. But for most attorneys across the country, the idea of just hoping that someone will voluntarily make payments on a discharged debt is just a non-starter. So.
Yeah. And so the way this works is you have two fee agreements with your client, and the bifurcation comes from, you bifurcate your case into pre-petition work and post-petition work. So you have your first agreement with your client, which deals with the pre-petition work that you're performing. And at true zero down, you're waiving any fees you'd be entitled to, although some attorneys do collect fees for that upfront work. The second agreement is signed after the case is filed, and the second agreement is for all the post-petition work. And because you're entering into that second agreement after the case is filed, you're performing the work post-petition, and you're collecting fees post-petition, it doesn't violate the automatic stay or ultimately a discharge injunction. And so it's an enforceable obligation with your client for them to make payments to you. And some of the, like I said, more details. So, we try to push as much work into the post-petition arena as possible to help justify whatever the fee is. Because again, you're not moving pre-petition fees post-petition and collecting them. You're either collecting or waiving any fees you earn pre-petition, and post-petition, you're only collecting fees for the post-petition work. So what we do is we have attorneys file basically a bare bones petition. So just the documents that are required to start the case. Some places they call it a skeleton, sometimes it's a rush, sometimes it's an emergency. I heard a fourth term for it the other day, I can't remember what it was. But
short petition, yeah. Some places call it short petition.
Yeah, so the name changes, but the bankruptcy code's super clear what you have to file to start a case. So you file the documents that are required to start the case. Once it's started, client comes back, signs that second fee agreement for you. You then prepare all the statements and schedules, get them on file with the court, and complete the case in the normal manner. And that creates the obligation for the debtor to make payments to you.
And I can almost hear the questions in your heads right now about how, do we do this and make sure that we're completing our diligence. And, we readily concede that most attorneys now under the traditional model complete their diligence by preparing the schedules and statements along with the petition. And there's absolutely nothing wrong with that. And if you've got a client that can pay up front, there's a lot of efficiency in both doing the diligence and completing the schedules and statements at the same time. Yeah. But in order to offer post-petition payment terms to clients and to strike that balance that makes it economically feasible for you and still offers clients that option to make the post-petition payments and potentially to start their case for zero down, you have to strike a slightly different balance, but you can't forego or avoid doing your diligence. And so what we talk to attorneys about is using a robust intake questionnaire, having a robust consultation process where you're sitting down and talking through the issues to make sure that you tick off a few key boxes. One is that they're eligible for bankruptcy. And so if you have any question about whether or not they're below median, you may need to do a means test to make sure that you can tick off that box. You need to make sure that it's in their best interest, not only to file a bankruptcy, but the Chapter 7 is the best choice for them. Do they have any issues that would suggest they ought to go into a Chapter 13 instead, for example? And then finally, you need to uncover those landmines that might lurk out there that we've all unfortunately had blow up in our faces after we've filed cases. And there's no system that's perfect to uncover all of those, but you need to do your best in your pre-petition diligence to make sure that you're uncovering those.
Yeah, the main things you're looking for, the non-exempt assets,
Sure.
there may be some bankruptcy planning you could do to protect them, looking for preference payments in case there's anything you need to undo or unwind before you file the case.
Fraudulent conveyances,
Yeah.
the typical, spate of things, including potentially non-dischargeability issues too. Those are less common, I think, obviously, in a typical consumer Chapter 7 case. But you need to tick off those boxes. And you can absolutely do that without actually preparing the schedules and statements. And so we have you do that process, file a short or emergency petition, and then the debtor comes back in, signs a post-petition engagement agreement, and moves on with the rest of the engagement in the normal fashion.
Yeah, and in fact, we'll talk a little bit about forms later, but one of the forms we do have available for attorneys is a pretty robust client intake form that you can use in your practice, and we're happy to share that with you.
Yeah. So, people inevitably want to know whether there's good case law support for this or what the legal background for that is. And as Matt mentioned, we've written and spoken on this nationally now for quite a while. And it turns out that there is actually quite a long history of the practice of offering post-petition payment terms to clients. It goes back about 25 years. Yeah. And the initial attempts to try and come up with a solution to, the problem that anything that you don't collect under a pre-petition engagement agreement gets discharged or collection of an estate. The ways in which attorneys have tried to do that have been, very diverse. They've ranged from collecting post-dated checks to just engaging in straightforward collection efforts on a pre-petition engagement agreement. But in 1999, so about 5 years into the case law history of folks trying to find a solution to this, the Ninth Circuit came out with a decision in a case called Hines, and then there was a follow-up decision called Sanchez that determined that while the contract itself, the pre-petition engagement agreement, was discharged, that attorneys don't earn fees until they actually do work. And so there was still an equitable basis for collecting fees post-petition under an unjust enrichment or a quantum merit theory. And while that conclusion has been criticized by some courts in the ensuing 20 years, the basic principle that you can collect fees for post-petition work has kind of remained very vibrant and valid throughout the case law. What we saw in the years after that were different attempts to try and figure out a procedural mechanism to do this that kind of culminated in about 2012 in a few decisions that kind of came to the same conclusion. And that is that you could bifurcate the engagement into these two separate agreements, and that the post-petition engagement agreement wouldn't be discharged, wouldn't be subject to the stay, and could therefore be used to offer post-petition payment terms to clients. There was a case in Florida called Walton that involved the Clark and Washington firm. There's another case out of Detroit called Slavink. And more recently, just actually earlier this year, there was a decision that came out of Utah that's gotten quite a lot of press nationally. It's called Hazlitt. And the Hazlitt decision involved an attorney basically following the exact model that we promote, which is splitting the engagement into two agreements and making sure that you tick off the boxes of disclosure to the client, disclosure to the court, that the fees are reasonable, and so forth. And the court in Utah approved that structure 100% without problems.
Yep.
And there, both before and after, have been a number of cases that have come out where attorneys have stepped into some potholes, which we're going to go over here in just a couple of minutes, that are easily avoidable by you, but nonetheless commented that bifurcation was still a valid way to structure an engagement, but that in one way or another, attorneys had made mistakes in how they had done it.
Yeah, and another really important piece of though is, I believe it was in August of this year, Clifford White, who's the head U.S. trustee in Washington, D.C., gave a speech, and he talked specifically about the Hazlitt decision. And he basically said that he agreed with the analysis in the case, and he commended it to the trustees and to the bar to follow the analysis in that case and reviewing to make sure that bifurcation is being done correctly. So yeah. It was really viewed as an endorsement from the U.S. trustees.
So, the Hazlitt decision really broke things down into four buckets. One is whether or not it was in the best interest of the client to offer the post-petition payment terms. The second was whether or not there was adequate disclosure to the court. The third was whether there was adequate, probably mixing these up here a little bit temporally, but the third one is whether there's adequate disclosure to the client. They really understand what they're doing. And then the last one was reasonability of fees. So maybe we can kind of walk through each of those issues and talk about how our process and our forms kind of tick off the boxes on those things.
Yeah, so we provide recommended fee agreements to our clients. It has our clients, the attorneys, that they will use in their agreements, or the agreements between them and the debtors, which discloses everything that's required to be disclosed to them. We also, the disclosures to the court are done through the Form 2030 fee disclosure. So that form, we've added additional disclosure in there to describe very clearly about the pre-petition and post-petition arrangement, our involvement in the process, and we'll talk more about the services we provide, and just make it very clear to the court exactly what's going on, because as I'm sure you've all heard people say, always disclose, disclose, disclose. You can't over-disclose. Really in any case, but particularly in a bifurcated case with a financing arrangement.
No, and I can tell you in the cases where attorneys have not done this correctly and have gotten into some amount of hot water over this practice, the common factor in every single one of the cases was disclosure. Either disclosure to the client was inadequate or disclosure to the court was inadequate. And so we've really worked hard to make sure that our documents, including the Form B 2030, tick off all the boxes. And in fact, one of the articles that we wrote for the ABI Journal that came out just this last July focused specifically on that topic of disclosure and kind of walked through the language that we incorporate in our recommended disclosure to our clients.
Yeah. So maybe we should talk about the services we provide.
Sure.
So when attorneys decide to offer this to their clients, they have a few challenges that they face. One is that if you're doing the work and rather than getting your money up front, you're not going to wait 12 months to get your payments. It creates a cash flow challenge. The second thing that happens is when you start collecting payments, it really creates a payment management challenge. An example we often use is if you do 10 cases a month, and let's say they're making weekly payments, which clients can do when they work with us. By the time you get to the end of the year, after 12 months of 10 cases each month and weekly payments, you're collecting 600 payments a month from debtors. And it's not like, they're consistent. I mean, there's, as you know, collecting them up front. I mean, they call in, they make changes, there's payments don't go through. I mean, there's always something going on with them. And so it's quite a bit of work. And so we fix those challenges though, because we provide a line of credit to the law firms to take care of the cash flow problem. And then we manage all the payments that their clients are required to make. And we use technology and trained staff. We have economies of scale that no law firm could ever come close to matching us on. And we're very effective, and it's a very friendly process. Like, we don't do hardcore collections or anything with people. We work with them, and we call it relationship-based payment management. So, if they don't make a payment, we send them friendly reminders. The technology gives them text messages and emails where they can click links and update cards, make payments. If technology doesn't work, then the human element steps in, reaches out to them, find out what's going on, and just, we have a series of steps we do to try to encourage them to make the payments.
And the messaging is all really consistent. So we talk about the fact that this is a part of that fresh start, that they begin by filing the bankruptcy. And we always remind them that we're here, managing the payments for you, the attorney, on the bankruptcy case that was filed. And we talk about, helping to get them back on track. And there's all kinds of solutions to the common problems that come up. We have people call on a daily basis who've lost jobs again, or perhaps they've been sick and they've missed some work. The upshot of which is that they're not able to make, the payment that's scheduled this week. And so the discussion is always a problem-solving, collaborative kind of discussion with them about how we can try and get them back on track. And the solution might be that we take the missed payment and split it up into smaller chunks and add it to their next several payments. Or it may be that we'll just go ahead and forbear a payment and throw an extra installment onto the payment arrangement, which doesn't cost you or them any differently under our system, but gives them the flexibility to deal with, the vicissitudes that debtors unfortunately always experience.
Yeah. And so the other services we provide besides the line of credit and the payment management is we provide credit reporting. And so credit reporting actually is a really big deal. When clients come to your office, whether they ultimately accomplish this or not, their goal is to restart their financial life. They want to get the creditors off their back. They want to rebuild their credit. And in an initial consultation, if you can explain to them how you work with a company that reports the payments that's going to help them start rebuilding credit right away is very powerful to debtors and helps encourage them to sign up with you. And then the credit reporting also helps us with getting consistent payments from the people.
Yeah.
So it's also another incentive for them to make those payments to us because we'll report the payments positively to the credit bureaus.
No, and I know, Matt, you had this experience, so did I, and I'm guessing everybody who's watching the webinar did too, that, you'll have debtors who just don't understand the process really well, and you've done a good job in the bankruptcy and gotten them their discharge, and they come back in and say, hey, I don't understand. This is still showing up on my credit bureau report, and my FICO score is still in the dumps. Like you said, you're going to get rid of my debts. And they don't understand that you're getting their debts discharged, but it doesn't in any way affect the reporting of those, those defaulted debts on their credit reports. And so not only is this a way for them to get the fresh start through the bankruptcy and access the system affordably, but it's also the first step that they can take towards rehabilitating their credit score, which is very, very powerful for them.
And the other things we offer then are the forms and training. We talked a little bit about the forms. We have all the forms you need and even extra forms you may just want to incorporate in your practice. But we also do training. So when attorneys sign up with us, we have what we call our Lunch and Learn series. And so we have training videos that are not just for the attorney, but for staff as well, to make sure everybody understands how to do zero down, how to bifurcate correctly, about the disclosures, the timing of documents, everything you need to know. So we do the training videos, and we do live Q&A with our staff.
You forgot the most important part. We buy your office lunch. We will feed you while you're doing all of these things.
Yeah, so lunch and learn. So yeah, we do that, and because we really want to make sure everybody in your office knows exactly how to do this and do it right. Because again, there's a right way to do this, and there's plenty of wrong ways to do it as well.
Well, I can tell you a lot of the mistakes that we see being made in this practice have to do with staff not fully understanding the process, and so we're very big on trying to make sure that both you and your staff are up to speed. And if all of you are anything like Matt and I were in practice, we rely really heavily on paraprofessionals and legal assistants and other staff members, to kind of walk the debtors through certain parts of the process and to get documents in order and stuff. So we're big on trying to get all of you together and watching the videos and making sure that you have the chance to answer questions and things like that.
And then the last thing we offer, which is becoming less important, but it's still important, is our defense guarantee and indemnity. So, in many places, this is a very well accepted practice, and the trustees and judges are very familiar with it. They don't even bat an eye when they see a bifurcated case come through. But there are places around the country where it's very new, and some of the judges just don't even know what bifurcation even is. And so sometimes judges will, call a hearing to ask, what are these disclosures? What's going on with this client? And but we'll defend you. I mean, it's not really always a defense. Sometimes it's just providing information. But we'll do the briefing. Dan, who is a nationally recognized litigator, will get on an airplane, attend the hearings in person, just be able to explain everything to the judge or trustee who may be asking questions. And so we have you covered. And not that it's happened yet, but if, heaven forbid, we actually were to lose and you followed our best practices that we give you, we would also indemnify you up to $50,000 in any fees that you had to disgorge.
Yeah, so, the fact is we're very confident in the case law basis for this, and that the process that we've designed follows that case law and the best practices that have been established out there, which is why we feel comfortable standing behind you. But we also understand that for those of you who are in a district where it is a newer concept, and perhaps there isn't, broad acceptance of it yet, or even really awareness of it yet, that folks might ask questions. And, so the defense guarantee and indemnity at the low end of things, we'll have U.S. trustees that will ask questions at a 341. And so I will step in and draft a letter to that trial attorney at the U.S. trustee office, and we'll enclose copies of our articles and the cases and so forth, and just educate them about the process. And then Matt mentioned that judges occasionally will see, a bifurcated case come across their desk, and they'll wonder what it is. I had a case out in Brownsville, Texas, just a little over a month ago, where exactly that happened. The judge just sua sponte scheduled a conference, asking the debtor and the debtor's attorney to show up to explain the two-contract process that they saw. And so we filed a bench brief before the hearing, and I flew out there and presented to the judge, and we made a proffer of, the circumstances of the engagement and so forth. And the judge said very simply, I have no problem with this process. And that was the end of it. But we're there from beginning to end. I mean, whatever that might involve, we're going to stand shoulder to shoulder with you and make sure that you're protected and the trustees and judges are educated about the practice and how you followed best practices.
Yep. So I guess one thing we can talk about a little bit is about the actual financing that we provide. As I mentioned earlier, it is a line of credit that we provide to your firm. You get to make draws on that line of credit based on the value of the payments that your client owes you, the receivables. It's not factoring. Factoring in our view is fee sharing and violates the rules of professional responsibility. But ours is not that. It is a true line of credit that you make draws on.
In fact, for those of you who may not know, factoring is actually a process where a lender comes in and buys your receivables. So they own your client's receivable, and we don't do that. We take a lien against it to secure repayment, but it is a line of credit to the firm, which is very different.
Yep. And then we fund our attorneys twice a week. So our goal is to get money to you right away. So we fund attorneys every Tuesday and Friday. And then obviously we manage all the payments from your clients and apply those to the line of credit.
So we do have some modest underwriting standards, but they're very easy to understand and very easy to apply. So if you have a debtor come into your office, let's say it's the single mom we were talking about earlier, she needs to be making $2,000 a month of gross income. If she doesn't, we can still qualify her with a third-party guarantor. So if she had a mom or dad or somebody that wanted to sign off on it, we could still finance that case. But typically the debtors need to make $2,000. And that can be through a combination of sources. Really, the only thing that we don't count is unemployment compensation. But if they're gigging on the side for Uber, or they have a couple part-time jobs, or it's jointly filing spouses and they've both got, jobs to contribute, we look at, the complete situation there. The other requirement is that the payment monthly can't exceed 10% of their gross income, which is very, very easy to satisfy in most instances. Our typical range, for financing contracts is between $1,000 and $3,000. We have made exceptions on both sides of that spectrum where, the circumstances justify it. I mean, we have some attorneys in Hawaii and Orange County and New York and some places where they're able to charge more than $3,000. And so we accommodate that, but our basic range is 1 to 3. So, if they're making $2,000 a month worth of income, they'll qualify for a $200 monthly payment, which is a $2,400 post-petition fee. So the economics all kind of line up there.
Yeah.
The other major thing is that they have to have a bank account or a prepaid debit card on which their wages are deposited, because all of our payment collection activity is electronic. It's either debit card or ACH payments that we're looking for.
Yep. And so, a question we get asked by attorneys a lot too is when they sign up with us, does that mean they have to put all their cases through us? Do they have to be zero down? All those decisions are up to the attorney. You don't have to do zero down. You can do a low down if you like. You also don't have to put all your cases through us. You can stop at any time. But it's really, we always call it the incremental business model. So, the clients that can come in and pay you up front, don't stop doing that. Keep doing that. What we're talking about doing is helping those people who can't pay up front. So those clients are the ones that you'll put through the system with a zero or low down and have us manage the payments and advance you the funds under the line of credit.
Now, having said that, we do really strongly advocate, because of the informed consent issues, that you provide both options to basically everyone that comes in the door, so that it doesn't look like you're steering them one way or another. And we have, among all of our other tools, we have a one-sheet presentation that you can push across the table to your prospective debtor in a consultation that says, I have two options. You can pay upfront for my services, and here's the price for that. And then if it's different, here's the price if you want to pay over time, and here's how that breaks down into weekly, bi-weekly, semi-monthly, or monthly payments. And make it very plain to them what those choices are, and then let them choose. That's actually the best way to demonstrate that you've got informed consent, is that you present options and you let the debtors choose what's best for them.
Yeah, because nobody knows what's better for the client in terms of paying up front or doing payments over time. Nobody knows better than the client, so they get to choose.
But really, as Matt said, this is an incremental business model. I mean, what we're looking to do is to help you grow your practice by helping more people. I mean, that's the reason we're sitting here talking to you today. And so if this is a way, and we know it is a way, that you can grow your practice by helping more people, then, really what you should be focusing on is the big picture of, your overall practice and your overall bottom line, and helping more people in the process.
If we talk about how people get started, if they
Yeah, so we talked a little bit about onboarding and our lunch and learn process. We've really tried to make that as simple as possible for you. So you're going to have a slide at the end of our webinar here that's going to give you access and credentials to get into a portion of what we call Fresh Start University, which is a secure portion of our website that has all of our training videos and our forms and everything. And because you took the time to, sit with us in the webinar today, we're going to give you access to that so that you can take a look at all the documents for yourself. And if you want to watch some more videos about how the nuts and bolts of this work, they're going to be there for you. But that's also part of that onboarding program that we implement through the Lunch and Learn. And what I would say is beyond just the Lunch and Learn, we really go out of our way to try and make sure that, we make it as easy as possible for you to adopt this practice and to change your processes slightly to accommodate it in a way that'll be, as the least disruptive to your practice as possible.
Yeah. So hopefully at this point, it's you guys have gotten the vision and you understand, how this does help more people and it helps your practice. But if anybody's still skeptical out there, one thing we always offer to people is we find that the clients or potential clients have come to your office but didn't retain you. Had you actually had the zero down option for them, that they would have retained you. And so what we've done is we put together an email that it's a template, so you can take the email, change it how you want. But what we ask attorneys to do is send it out to the people that came to your office in the last 30 days. You can go back further if you want, but it's most effective for the last 30 days. The ones that came in did not retain you. And all the email really is saying to them is, hey, when we met, you didn't retain me. I wasn't sure if money was the objection, but I have a new option or contemplating getting a new option where I can file your case right away and you can make payments for me 12 months later. And the email, it works so well that most attorneys will get about a 50% response rate back. So if you send it out to, say, 10 people, you'll find generally you'll get 5 people come back to your office who want to sign up for the program and move forward with you as their attorney.
Well, the beautiful thing about this too is, the whole point of this webinar is growing your practice and helping more people in 2020. And so if you were to send that email out now and get back the kind of response rate that we're talking about, which we see pretty much across the board, it's a way that you could potentially put several $1,000s to your bottom line right out of the chute and kind of kick off 2020 in a big way and know that you're doing it for all the right reasons. You're helping people that walked away without retaining you because they couldn't afford to.
Yeah. Another great resource we have too for attorneys who want to grow in 2020 is we have some really good third-party marketing companies that we can recommend. And we have no financial relationship with them whatsoever, but we've had lots of clients use them and they've done a phenomenal job of helping people grow their practice. So when you use some professional marketing along with offering a zero down option, it really is like pouring gasoline on a fire in terms of you're going to help so many more people and really grow your practice.
Yeah.
So.
All right, let's check and see if we've got some questions queued up. I haven't been watching through the presentation here. Okay, so Tom asks about a local rule. He's calling it an unbundling rule. That's a term that we see quite often. So the question basically is, how do I do this if I have a local rule that says that once I file a case, I'm obligated to handle the entire case start to finish? How does bifurcation work with that? We get that question a lot, and I've actually briefed this issue for a number of judges and trustees over the last little bit too. There's actually no conflict between these two approaches. So unbundling rules are designed to make sure that debtors have the benefit of an attorney through the entire Chapter 7 process. So typically what they say is 2 things. They say if you start a case, you can only get out of it if you file a motion and the court gives you an order allowing you to withdraw. That's not a problem. They also, a lot of times, will have a list of services that have to be provided to a debtor. You can't carve out pieces of it, which is why those rules are technically called limited scope representation rules. The notion of unbundling is kind of a colloquialism. Given that the purpose is making sure that debtors have representation through their entire case, bifurcation is actually entirely consistent with that, because it is a way in which you can make sure that debtors who couldn't otherwise afford to hire an attorney, let alone hire one to handle the entire case, can in fact do that. And as we've looked across the country and we kind of keep a database of these rules in different districts, we've not seen anything that conflicts with bifurcation. In fact, more often than not, you look at the rule and there's nothing in it that even speaks to how you structure an engagement or what you need to do to document the engagement. So not a problem there.
Anything else?
Oh, you think we must have done a pretty good job of answering questions as we went, because I think that's it. So again, just to kind of sum up, we'd love to be a big part of helping you to grow your practice and help more people, starting in 2020. This is a practice that's been adopted pretty widely. I mean, I can tell you we're working with over 300 firms in 42 states right now. Whether you know it or not, it's probably already happening in your district. And maybe some of you are already starting to feel the competitive pressure of it, because once someone starts offering zero down terms, in a particular market, it tends to get a lot of traction, and the folks who are not offering it feel the pressure pretty immediately. But we'd love to help you with this. We're here to answer more questions if you have them. After the webinar, Matt and I are both very accessible to you. We have a great staff of client relations and business development people as well who are standing by that can answer questions that you may have as well. So we're going to put a toll-free phone number, and oh, hey, we had one question just pop up in the chat. So George asks, how should a client answer the question from the trustee as to whether all fees have been paid for in the bankruptcy? Well, so the answer is you answer it honestly. In the Form 2030 or your Rule 2016B declaration that you file in the case is going to be very clear about the fact that a portion was paid or waived pre-petition and a portion still owing post-petition. We've got narrative disclosures as well that explain that you're using this bifurcated process, 2 separate agreements, specifically identifies what services are going to be paid for under each agreement. So there's really, it probably won't be a question about whether all the fees have been paid or that sort of thing. If there's any question, it'll be about how you did it and whether it met the HAZLIT guidelines, because as Matt said, the U.S. trustee program is very quickly climbing the learning curve, that it's not a question of whether you can bifurcate, it's a question of how you bifurcate.
Yep. And so actually we got another question. This is a great question. Jennifer asks, is it possible to send out the templates before we decide to use your service to see what kind of feedback we get? And absolutely. So we are all about communications with the U.S. trustees. And I assume that's who you're talking about sending it to. So yeah, we're all for sending information to the U.S. trustees. We find they vary a lot in terms of whether or not they're even going to respond. In some places, the U.S. trustees just won't even answer if they like it or not. Other places, they're happy to meet with attorneys and go through the forms, you make suggestions, say they like them or whatever. But regardless of, what it may or may not be in your area, we're all for providing information. And I'd say reach out to us. Yeah. Let's put together a package, because in addition to the forms, we would like to just include some of the case law, some of the descriptions of what happens and the like, because some U.S. trustees just aren't familiar with this. We don't want to give them less than the whole picture of exactly what it's all about. So
I'll tell you, in the districts where it's difficult to get the U.S. trustees to engage, ahead of time to answer questions or to share concerns or ask for more information, what we recommend is what we call a noisy filing, which is that you go ahead and file a bifurcated case and you alert them to the fact that you're doing it and that you followed what you understand to be the best practices in doing it, and invite them that if they have any concerns about it, that they let you know. Because the fact is that there is solid case law behind this. There is a growing awareness and acceptance of it across the country. But if you are in one of those districts where there just isn't any particular case law, or the U.S. trustee is not aware of it, the only way that you're really going to be able to engage them is to file a case. And so we recommend what we call a noisy filing around that. And
again, it's part of our practice too. We'll be there with you the whole time in terms of how to notify them, how to respond to them. We'll be there with you.
Yeah, and the thing about a noisy filing too is that there's no question that you're being upfront about everything. You're telling them that you're doing this case this particular way. You're explaining to them the basis for it being done that way and why you think it's completely legal and ethical. And if they have a problem with it, they'll let you know and we'll deal with it. And, not only take care of the briefing and the oral argument, whatever else is involved, but will indemnify you as well. So there's really no risk to you at all, reputationally or legally or economically in the equation. So that's the way I'd go about doing it if you have concerns and can't seem to engage them in advance. Okay, it looks like there's one more question that popped up. Oh, maybe that's the one we just answered. Yeah, it looks like it is. Okay. All right. Well, we want to thank you for taking the time today to listen to what we had to say, and hopefully you'll take advantage of both the email that we have that you can send out to folks who didn't engage you, but also access Fresh Start University and take a look at our additional information. There's a toll-free number as well that you can call that'll be on the slide at the end of the webinar here. And, you know, it sounds hokey, but there are literally people standing by that can answer your call and answer questions that you may have. And if those folks can't answer it, they'll pull Matt and I into it. You can also email us both directly. I'm Dan at Fresh Start Funding, and Matt is Matt at freshstartfunding.com. It's very easy to get a hold of us.
Good. Well, thank you very much. And we look forward to speaking with you.
Yep. Happy holidays, everyone.
Yeah.